Good morning, good afternoon, good evening, or much more depending on your location. Please join in the struggle to liberate our people from the contraption. Like and share videos. Happy weekend. Today is a Market. I bring a news update. The suit seeking Kano's release based on his unlawful abduction lacked reference to any Nigerian law. Supreme Court said. Yes, it's no longer news that Supreme Court in Nigeria rejected the call for the release of Mazi Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, thereby sending him back to detention. Yes, justices of the Supreme Court, five-man panel of justices, nullified the previous order from the Court of Appeal in Abuja that directed that Mazi Nnamdi Kanu should be released. Yes, they said no court in Nigeria have the capacity, the legality to try him. So you don't have the right to try him. No court in Nigeria should try him any longer. That's what the appellate court said, while quashing the terrorism charges prevailed against him by the federal government. Say you lack the legality to try him as long as you are caught in Nigeria. Now, this judgment was written by Justice Garba Lawal and was delivered by Justice Emmanuel Agénťs. The Supreme Court overturned the Court of Appeal's decision, yes, precisely October 13th, 2022. Now, that judgment dismissed and quashed all the terrorism charges against the leader of the IPOB. But the Supreme Court emphasized that the Nigerian government's rendition, that's extraordinary rendition or unlawful transfer, if you like, the abduction of Mazi Nnamdi Kanu and subsequently extraordinary rendition of Mazi Nnamdi Kanu from Kenya to Nigeria did not deprive any court of the authority to proceed with the trial. That's according to this judgment written by Justice Lawal. They said that the suit seeking Kanu's release based on his unlawful abduction lacked reference to any Nigerian law. He added that appropriate remedy for such an action is for Mazi Nnamdi Kanu to file a civil case against the abduction instead of nullifying the court's power to continue the trial for the criminal charges the federal government leveled against Mazi Nnamdi Kanu. Yes. Now they said the Supreme Court then directed that Mazi Nnamdi Kanu should go and defend himself against the remaining 7-count terrorism charges before a federal high court in Abuja. Now this is what the Supreme Court said, talking about the charges, yes, being brought in by the federal government against Mazi Nnamdi Kanu. They said it remains 7. Of course, Justice Binta Nyako has struck at 7 in the 14 amended count charges, yes, against Mazi Nnamdi Kanu. Yes, when they extraordinarily renditioned him, they amended the charges. They amended the charges, and the charges was up to 14 or 15 count charges. I beg your pardon. After that, the Justice Binta Nyako struck at 8 count charges, remaining 7. Then the Supreme Court said he should go back to the Federal High Court to face the trial of the remaining 7 count charges. Now, what are we not talking about? The Supreme Court said that the abduction and the extraordinary rendition of Mazi Nnamdi Kanu is illegal, that the federal government committed offense. Yes, that's what they said in their judgment. And yet, you said it's not enough for Mazi Nnamdi Kanu to be released. Yes, they said the suit seeking the release of Mazi Nnamdi Kanu based on the extraordinary rendition, all right, is not known to law in Nigeria. Yes, how can you say that his abduction is illegal, that the federal government committed offense there, yet you said it's not known to law? So this is illegality. The Supreme Court committed atrocity, miscarriage of justice, by saying that the abduction extraordinary rendition of Mazi Nnamdi Kanu is not enough, because the appellate courts, yes, based their judgment on that. They said, you cannot try someone you abducted, you extraordinary rendition. So you cannot try him, because you as a government, you are trying to correct someone who did something wrong. And you yourself, in trying to do that, correct him, you have erred. You have gone against the law. So you cannot use illegality to go and correct someone you think has committed something that is illegal. Yes, you are accusing him of illegality. He said this person committed offense. And in trying to correct him, you have committed, a serious offense. So how are we going to do about it? So it then shows that this is double standard. Double standard. The Supreme Court has no reason not to have released Mazi Nnamdi Kanu, if not that they received an order from the powers that be. Simple. The judgment is clear. You indicted the federal government based on the extraordinary rendition, the abduction, everything. Yet you said you should go and face trial at the lower court. And again, you are the Supreme Court. Okay? The matter have gone to the Supreme Court. The Supreme Court has the final say. And now the Supreme Court is saying, go back to the lower court, that's the Federal High Court, to continue trial. Whatever that is in that judgment, look, the Supreme Court, the appellate court have said, look, they have quashed all the terrorism charges against the leader of the IPOB. Yes. And so, what the federal government is saying is that, look, they have appealed at the Supreme Court, saying, look, that the judgment of the appellate court didn't go down well with them, they rejected it. So what the Supreme Court should have said is this: whether the terrorism charges, against the leader of the IPOB, whether it holds water, whether Mazi Nnamdi Kanu committed any offense or not. So they should be bold enough to tell the world whether Mazi Nnamdi Kanu committed offense by his activities. Yes, than to say the Supreme Court, the lower court should control the trial, whereas the case has come to your table. So the Supreme Court is the final. For them to pass the buck to the lower court means that the federal government is using them to delay the release of Mazi Nnamdi Kanu. So this is a game plan of the federal government. They worked it with the Supreme Court to be doing this abracadabra. A matter that is before you, you are referring it back to the Federal High Court, a lower court, where the appellate court have adjudicated on the matter. So you want the appeal court to try the matter again? Yes, because if Mazi Nnamdi Kanu did not get justice at the Federal High Court, he will go to appeal again for the second time, whereas the appeal have adjudicated this matter. The case has gone to the appeal, just the appellate court, and they have made their own judgment. And you are the Supreme Court, you are the final, because the federal government rejected and they have gone to the Supreme Court. And now the Supreme Court is saying, go back to the base to start afresh from the Federal High Court. So if Federal High Court said, or if Federal High Court ruled in favor of Mazi Nnamdi Kanu, then the federal government will do what? They will approach the appeal again. To hear what again? Something that they have adjudicated. Anyway, nothing is impossible in Nigeria. All they are doing is abracadabra, because it's still the appellate court that gave the stay of the execution that the federal government was relying upon before they approached the Supreme Court. Yes, the stay of execution of the appellate court judgment. The appeal court made a judgment and quashed all the terrorism charges. Released Mazi Nnamdi Kanu, say he's free to go. They indicted federal government and Kenyan government of abducting the leader of the IPOB. It's still the appellate court, that appeal court. Yes, the federal government transferred the justices that delivered that judgment in favor of Mazi Nnamdi Kanu, and appointed new persons. And those new persons, they were used to stay the order of that judgment. Those new appeal court justices. Yes. the federal government used them to obtain the fraudulent stay of execution that stayed the order or judgment of the appeal court before they now proceed to the Supreme Court to challenge the judgment of those justices they transferred. So these are the legal issues, and we have seen it. So it has shown that the Supreme Court, they are afraid, they are fearful. They have relegated their duty to the lower court. Yes. So they want the matter to start from there again, to start coming up from Federal High Court to the Appeal Court, then to the Supreme Court again. No.